So I'd like to just introduce everyone but Craig. We have Lisa Filgiano, partner at Miller Thompson, who has extensive experience in estate litigation. I've had the pleasure of being a panelist with her on a number of occasions, and she's always wonderful. And Noah Weisberg is a colleague of mine at Hull & Hull and the incoming chair of the OBA Trust and Estates section. So congratulations. And then there's Craig, who we all know. So this panel discussion is about examinations for discovery in trust litigation. And I'm going to actually start with Lisa, if we could, about getting some admissions, if we can, from examinations.
Is this working? So I've been asked to speak to you this morning, or still this morning, about how to solicit admissions from a witness in order to use those admissions at trial. So before I go into what questions to ask and how to get those admissions from a witness, particularly when you're dealing with a witness like Craig that's not necessarily cooperative, I think it's important to take a step back and consider what the purpose of the examination for discovery is. And the way I see it is there are two main purposes, and one is in the title itself. It's an examination for discovery. There are parts of the case that you don't know yet. At the stage of an examination for discovery, pleadings have been exchanged, documents have been exchanged by way of an affidavit of documents. So you have a paper record of the case, but you have your client's version of the case. So if in this case we're acting for Brad, you have Brad's version of the events, and you might have some insight into what Jeff's version of the events are, but you haven't actually asked them those questions yet, or you haven't elicited that evidence. So you don't want to wait until Jeff is giving his examination in chief at a trial to discover what his evidence is going to be. So your examination for discovery is your opportunity to discover his version of the case. It's also your opportunity to obtain admissions from Jeff as that will support your client's theory of the case. So in this situation, you're trying to get admissions from Jeff that show that he breached his fiduciary duty and he wasn't entitled to the full amount of compensation that he pre-took from the trust. The other important thing to consider is how you're going to use the transcript at trial. So there's probably two ways that you're going to use the transcript and the admissions that you get. It's either going to be one, to impeach the witness, so to impeach Jeff if his version of the events differs between the examination and the evidence he's given at trial. And there can often be years between the date of the examination for discovery and the actual trial date. And it's not unusual necessarily for a witness's memory or recollection to change. Memory is not stagnant, and it's possible that there's inconsistencies between what Jeff says at the examination and what his evidence is at trial. But there can be more significant inconsistencies that you want to highlight by way of impeaching him at trial. And I'm not going to go through the process of how you would go about doing that, but there is a script that you can have with you at trial that's handy. And the other thing you might be doing with the transcript and the examination for discovery is actually to read it in. And that in order to do that, you would read it question and answer. So you'd read the question that you've asked the witness and the answer, and that would become evidence as if Jeff was sitting in the box giving evidence at trial. So when you're preparing for your examination for discovery and you're trying to determine how to approach the questions that you're going to ask Jeff, the use of the examination for discovery transcript is important to keep in mind. It's also important to keep in mind that you might have to rely upon the transcript entirely in the event that the witness becomes incapable or has deceased between the time of the examination and the trial itself. So you want to make sure that the evidence that you need with respect to your client's theory of the case has come through in your questioning. So when you go about preparing for your examination, I view two main ways of organizing yourself in order to solicit admissions from a witness. One would be to organize your examination chronologically, and that's kind of the most comfortable way of organizing your examination, and that's because that's likely how the pleadings have been drafted. That's how we think naturally. If you think about a movie, you start from the beginning, there's a middle, and there's an ending. So that is an easy, comfortable way of organizing an examination, and that's often the way most of us approach it. The issue with it being comfortable for the examining lawyer is that it also is comfortable for the witness. So the witness might be able to foresee the questions or see where you're going with a specific line of questioning. And there might be, if you see that happening, or if the case renders itself to it, you might want to organize yourself differently. So I would say it's always easiest to start by organizing yourself chronologically and looking through all the documents, and then when you're getting ready to actually prepare your questions, you might decide that there are certain topics that you want to ask out of context, so outside the chronology. You might want to ask about the house transfer to Giselle before you talk about all the trust settlement documents, because at that point Jeff might not be comfortable with where you're going and the criticisms you may have of the amount of compensation he's taken. So that it can be more cumbersome to organize an examination for discovery in a more topical fashion rather than a chronological fashion, but it can result in some good admissions from the witness where the witness might not even appreciate that they're giving you the admissions that you're looking for. And it's obviously always possible to jump between the two. So there's no rule on how you can organize your examination. It's your examination. You get to ask the questions. As far as tips for actually devising the question, so what should you be thinking about? I think the first tip is ask one simple question at a time. Do not bundle multiple questions into one question. And that's because ultimately what you're going to be left with is a written transcript of each question and each answer. And if there are 3 questions that you've put to a witness and there's one answer, it won't necessarily be clear what question is being answered. And it might become more difficult to rely on that evidence at trial, either when you're impeaching the witness or when you're reading the evidence into the transcript into evidence. So an example in this case of what not to ask would be, if you were examining Jeff, you wouldn't want to ask, when the trust was settled, you wanted to ensure that Giselle was taken care of because she had cerebral palsy and Brad did not need all of his money because he was going to be a doctor. Is that right? You've actually asked 10 questions.
I would have said that was a very confusing question. That's what I would have said.
Or
Right.
I think, I'm not sure Mel, who said, which question did you want me to answer, right?
Yeah.
Which was a good answer.
Yeah. So you want to be careful not to bundle all of the evidence that you need into one question. You have time. You generally have 7 hours to examine the witness. Take your time, break it down. You could, instead of bundling it all into one, you can establish that you could ask him that the trust was settled in the year 2000, and at that time Giselle had cerebral palsy, and that you believe Brad would go to med school. And you can work your way through all of the questions individually and get a very clean, clear transcript with a short question and a short answer that you can rely upon at trial.
Lisa, can you tell us, when you're budgeting time for examinations for discovery, is there some ratio that you say, like, okay, this is a 2-hour examination, I've got to put in this much preparation? The reason I raise that, I always think of a funny story of Rodney Hull, who was preparing to examine the key witness in an estate in the famous Fox case. And Ian, who was in the car with him, asked him, Dad, are you ready for the examination? And he said, oh, yeah. Here are my notes. And it was one piece of paper with 3 questions on it. And and this was an examination at trial. That probably isn't the standard of practice now, but how much preparation are you going to use to get ready for an examination for discovery?
Well, I think I don't think there's a hard and fast rule, but I think it depends on the amount of documentary evidence that you're going to have to go through in order to prepare for the examination. Because ideally, you want to be more prepared and know the evidence and the information better than the witness themselves, and that's not an easy task because the witness themselves has lived through these events. They have their own intimate knowledge of what's happened, so you need to be more comfortable than they are with the documents and with the evidence. But I think I would say on average it's a multiple of the examination itself.
Good.
As far as other tips, I don't know how I'm doing time-wise.
Yep,
but
you're good.
As far as other tips when you're trying to get admissions from a witness, and perhaps the example of the examination of Jeff in this particular case isn't a good example of this, and that's in part because it was a cross-examination, is that you should try to build a rapport with your witness. Yes, you're the examining lawyer and you're the one asking questions, and obviously you're representing the opposing counsel, so you're representing his son who's challenging his compensation and how he's discharged his obligations as a fiduciary. But a witness that you can build a rapport with that becomes comfortable with you may be more willing to offer up evidence that they wouldn't have otherwise been willing to give. So if you start with a difficult question to Jeff, if you say you stole money from the trust or you took more compensation than you were entitled to, he will immediately have his back up and be combative and be less willing to kind of play ball with you. Whereas if you start with a series of kind of simpler, easier questions, if you flatter him by asking about all of the effort that he put into getting Brad into Dear Aunt Agnes to begin with, that was his idea, and how well how you compliment him on how well Brad did both as an actor and financially as a result of it, you might find that he warms up to you and might be more willing to offer admissions.
That's actually a great, and there's a rhythm, right, to examinations as well. Noah, maybe I'm just going to turn to you on that basis.
Sure.
And before you just get into your discussion about preparing a witness, what about this preparing them for the lawyer that you know is going to be examining your client? Do you have any sort of tips for them, if you've got Craig or you've got Lisa or you've got someone else examining?
Yeah, I mean, I think what you want to do is make sure you fully understand what the issues in the claim, and making sure that those questions relate to it, and really thinking about the question that you want to be asking in order to support your claim at the actual trial of the matter.
Okay, good. And so you're going to take us through some of the best practices for preparing clients about to be examined.
Yeah, so I titled my paper, Avoiding La La Land. When I was a young lawyer, we had a very tight timetable, and we were busy preparing a client for discovery. And given the timing, we had to meet over a Saturday and Sunday. We basically spent all day with them going through tips, potential questions, and we got to the examination on the Monday. And suffice to say, I think the client was in La La Land over the weekend. Unfortunately, I don't think anything sunk in with the client. And at the first break, we pulled the client aside and said, "Okay, we got to talk about making an offer to settle." So I think, the hope that I can convey to the lawyers and the participants here is just some tips you can take to avoid situations such as those. So I know that Lisa has already discussed why we have discoveries, so I won't get into that, although there is some material in my paper about that. So what I'll do is I'll focus specifically on the involvement with the client. And really, this begins at the affidavit of document stage. This is where you want to sit down with your client. You really want to explain to them the claims that are being made and the documents which are relevant. What we do at my firm is we send out a letter quoting the rules and also sending out all the documents that they need to think about in giving to us. We always tell them to err on the side of caution and to give us more than to give us less. Sometimes it's daunting when the lawyer drops off a massive binder, but there's often relevant documents in there, so you want to make sure that they are included. And this also extends to finding out down the road if you had missed a document that the client didn't give to you, you've at least done the job of putting in your reporting letter to them the type of documents that you need and hopefully avoid a claim down the road. So after you've received the affidavit document, you send it out, and the next step at that point is scheduling the examinations. So at this point, there's two steps that we normally take. The first one is, again, we do another letter to the client, and we set out briefly what is going to happen on the examination day. We explain a little bit about what is expected of the client. I'm going to get to shortly some of the tips that we like to tell them, which I actually put in my reporting letter, but also explain what the role of the lawyer is going to be on that day. And we try to keep it somewhat simple. We talk about the ability to object, to undertake, depending on the examination, that will take certain questions under advisement. Again, just having that letter to the client can hopefully settle a nervous client and ensure that they'll perform better on the day of the examination. So after we send the letter out, we also have a meeting to prepare with the client. And while I was writing my paper, I had the opportunity to speak with the former Chief Justice, Roy McMurtry, and I was kind of going over some of the tips that I was going to include. And what he said to me was that the meeting to prepare, in his mind, was the most essential step that can be taken in preparation for the examination for discovery. So he had asked that I bold, increase the font, and underline that point on my paper. I didn't, but I told him that. But I told him that I would personally convey that message. So we've sent the letter to the client. We've planned the meeting to prepare, and at the meeting, we'd like to go over these specific tips. And, I apologize in advance if a lot of them are just common sense, but again, it's amazing. I'm sure you all have situations where we get to examinations and the clients just kind of go off on a tangent and just think to yourself, if only they listened to what we told them. So in my paper, I've said it a bunch. I'm just going to highlight what I think to be some of the more pertinent ones. So first and foremost, tell the truth. I don't think that requires much of an explanation. Secondly, so listen to the question carefully, and the client has to make sure they understand the question. From the vignette earlier on between Melanie and Stephen, Stephen was asking Melanie about the initial client meeting and who was involved, and Melanie kind of slowed him down and asked him, well, what exactly did you mean? What meeting? And she was very careful to make sure she was answering the specific question. And all of us are familiar with these legalese topics. We talk about dependent support, undue influence, testamentary capacity. We have a really good understanding of what these concepts mean, but it's often the cases that clients don't. So we tell them that if you don't understand what's being asked of you, if it's too legalese, if we're talking about sui juris and random Latin phrases, then make sure to ask the question if you don't understand. Only answer the question that is going to be asked. We just talked on this panel that there was a great little scenario where Stephen asked multiple questions in one ask, and Melanie was careful to break that down. It also ties into what Lisa said about the importance of getting the specific question and the specific fact you want from that question. The next tip is to not guess. We don't always have the right answer, and sometimes, these are years after affidavit of documents and instances have been prepared, as Lisa mentioned. And, if you don't know, then don't guess. And, again, another great example, which Melanie did, was she didn't recall having a specific question conversation with Brad, and so she said that, and she decided not to guess. Speak slowly and clearly. This is something that's very important, and I'm actually trying to remind myself of that right now. Don't speak over people, which is what Lisa mentioned. It also is really important for, as Lisa mentioned again, for the transcript. And when you're preparing undertakings and refusals chart, you really want to know who said what the question was, and having that nice break in between the question and the answer will certainly help the lawyer. And we tell the client that to, ensure that it makes our job a little bit easier. And I've always been taught to be an active listener. When people are talking to me, I smile, I make eye contact, and I tend to nod. So because it's a written transcript, we remind clients don't nod. Make sure you say yes. And, almost at every examination, we ask the client to don't nod, but to speak the answer. Another tip we tend to tell our clients is if you receive the information from someone else, then you should make that clear in your answer. We're often dealing with family and sibling disputes, and one client says to another client that their brother told them. If it's not direct knowledge, then make sure you make that clear. Another tip that we tell clients is to if you're estimating, then make sure to admit that. We deal with numbers and dates, and it's very hard to lock down what the specific dollar amount was in a gift that dad made to the child, or the specific date when you thought that someone lost testamentary capacity. It's okay to say, in January of 2014, or you don't have to know the exact date. As I'm sure all of our clients are in any event, we do remind them to be polite and respectful. I think in all the vignettes that we saw this morning, every single actor was undoubtedly polite and respectful. An important point that we go through with our clients is not to lose your temper. These are heated disputes. There's a lot of emotion involved. Siblings do not like each other. So the role of the lawyer is to object, and it's up to the client to answer the question. Melanie, when she was talking about the elections that she was facing with her firm that she lost, Stephen went down a great path of why she lost the election, and Melanie, although she had no counsel at the time, said this is where my lawyer would be objecting. But it's also important to remind the client that we are dealing with dicey facts, and unless the lawyer objects, then you should be answering the question. We had a dependent support file where there was a challenge over whether someone was a spouse, and there were questions of a sexual nature, and the client kept on looking to us, hoping that we would object, and we allowed the line of questioning, and fortunately the client maintained her composure and answered the questions. I have a habit of doing this, and we tell clients, don't let the lawyer restate your answer and to accept their answer. If it's not accurate, it's up to you to say what you want to say, and the lawyers will often, in an attempt to understand, try to reiterate what the answer is, but make sure it accords with what you've been saying. Tying back into what the former Chief Justice Roy McMurtry said to me is often lawyers will ask if you've met with your, often a lawyer will ask the deponent if you've met with your client, with your lawyer before, and it's perfectly okay to, and it's these days almost necessary, so you can certainly tell your client that it's okay, we've had those discussions. Obviously you want to remind the client that communications are privileged, but the fact that they met is not a big deal, and we all do it. There's no need to memorize. What you don't want is a client to sit there like they've just staring down the whole time and trying to say exactly what they've been told. Best recollection is good enough, and sometimes when a client's got a good flow, which is what we've discussed earlier on, it kind of suggests that they're going to be a credible witness. Lastly, my last tip is examinations can be long. They're often spread out throughout the day, and we like to have our coffee breaks and our snack breaks. If the client needs a break, it's okay to ask for one, and we tell them that, and usually counsel will be obliging. So those are the tips that I've highlighted in my paper, and depending on the type of client you have, if they're a nervous client, if they're a confident client, we do like to put those in our reporting letters beforehand, if for no other reason, to avoid the scenario where your examination for discovery goes horribly and your client gets grumpy with you and perhaps decides to bring a claim. You've at least papered the advice that you've given them.
Thanks so much, Noah. Just before Craig, you hit on sort of, you're going to talk about professionals, and pretty much everybody in this room would fall into that category if they're being examined for discovery, and there's some specific issues there. But just about preparation versus coaching, and I sort of open that up. Maybe Craig, if you've got a few, what's the line? What can you do? What can't you do as far as helping get ready for an examination?
Well, Noah hit on it in one of his first comments in preparing a witness, and the truth is the truth. And coaching, if the intonation is, or the intention is by that word, that it's coaching to a different version of the truth, then that's offside. And so that should be the guiding principle, frankly, when you're talking to your witness about how to approach an examination. However, with preparation, you do have a case and a position that you're trying to make before the court. So in preparing the witness should actually understand the case. It doesn't mean they have to understand the case law, but that they need to understand what the theory of the case is. And oftentimes people think preparing a witness means turning the page. Did you make this note? When did you make it? Who was sitting with you? Well, how does that tie into the position that you're going to be arguing before a judge? How does that tie into the other facts that you're going to try to elicit from the other witnesses? And so when I'm preparing a witness, I'm actually not their friend. I play devil's advocate, and I want them to know that they're going to get pressured by the other lawyer, and I want them to know that there's going to be uncomfortable questions, because they have to understand how to use the facts that are true to answer those questions, and not get put in a position where they get uncomfortable because they haven't had their lawyer press them. If there's a difficult issue, there's a difficult issue. And very few estate litigation cases do not have difficult issues. And they can be legal, they can be factual, they can be emotional. Sometimes it's, why does mommy love me more or someone else than me in the family? Why am I not getting the same thing? If there's issues of abuse, all of these kinds of things which are secondary to the actual issues, potentially secondary to the issues in the thing, are issues to be dealt with. Because if there's a question on the examination and you haven't touched upon it with your client, they might sink themselves on the examination. So coaching, to me, means coaching a different version than the truth. Preparing means having your client understand what the overall theory of the case is, so that they can take different facts and answer any question. Because as Lisa said, it may not be chronological. It may not even make sense to the person who's listening to the questions to go, where is this going? And so if it's by issue, then the witness needs to be prepared to deal with things out of order.
Lisa, do you have any comments about preparing, the actual process of preparing a witness? The one thing sometimes you get witnesses who are hoping that, they're not gonna know about this issue. Well, the odds are they're gonna know about those, especially it's like the major issue. I don't think they're gonna miss this fact. It's kind of crucial. So, the hope is, trying to temper their hope is important. Do you have any other suggestions?
Yeah, no, so certainly hoping that the lawyer is not going to ask them the difficult question is not the right approach.
Right.
And I think kind of to Craig's point is you're not always your client's friend when you're preparing them for an examination, and you may have to do some mock examination questions with them and ask them those hard questions so that the first time they're answering it is not at their examination.
Great. Gregor, what about professionals, and how are you going to deal with that?
Well, first of all,
And
to use a baseball analogy, I'm pinch hitting today. and that's for Sean Lawler. Sean Lawler's paper is found at tab 12 of the materials, and it's entitled Examination for Discovery, Planning and Preparation in a Professional Negligence Case. So it's a shout out to Sean for preparing the paper, and I certainly urge you to take a look at the paper. And so I'm just going to try to do a bit of justice to the topic and touch upon a couple of things. So what's true in a regular examination is true in an examination of a professional. The rules don't change simply because it's a professional. But how the context comes about with a professional can be different. So in the case of a lawyer could be sued outright in an action, okay? Making them a party, making them the recipient of the claims for damages and claims against them. It might be it could be the result of a will challenge. It could be a drafting error. It might be a state plan that doesn't meet the testamentary intentions. Or doesn't reflect them, rather. There's a whole bunch of different issues. But if there's a will challenge, oftentimes the lawyer's not named as a party. And so it's set up such that someone else is managing the estate, and those that have a potential financial interest in the estate are battling each other. And the parties, at least first instance, just want the lawyer's file, and they want potentially to do examination of the lawyer. So that's a different scenario, per se, than when the lawyer has been sued by way of an action and is named as the only defendant, or a defendant together with his or her firm, and the allegations are made directly as against them. So the approaches are different. With respect to the application, it may be that once the file is produced, as a lawyer on the opposite side, you want to consider whether you even need to do the examination. Is the file enough to be able to go to a mediation with all of the parties, or do the parties feel that they need to do the examination of the lawyer? My preparation of a lawyer on either side, or my questions, won't necessarily differ, because you are going to take the lawyer through his or her file, and you're going to talk about when did the retainer start, and you do the who, what, when, where, and how kind of questions that go along with that. And as you saw Stephen, you're going to start the process by finding out something about the lawyer, what the qualifications are, how long have they been practicing, was this their first year of practice, or have they been doing this for 35 years? And it may be surprising that you may have a very experienced lawyer, but who has never drafted a will, and it may be the first time that they've drafted a will. So even if you have someone with 25 years of experience, it's worth asking the initial questions as to their experience and how did they come into the file. And then you go through the retainer. What did the retainer entail? And then you're going to take them through all of their correspondence, their notes. Are there docket entries? Are there things of that nature? And don't think per se that if you're the examining lawyer, if you're the examining lawyer for the plaintiff against a lawyer defendant, that simply because there's not great notes in the file that that's a slam dunk case. There can be very good circumstances and believable circumstances where someone's been representing someone for 10 years, have done 50 different things with this client, and so on this particular item they might not have all the notes. It doesn't mean that that is the better practice not to have the notes. I'm looking at it from the standpoint, if I'm the examiner of that lawyer, that I just don't end my case by saying, and you have no notes. Because what happens if they have a practice that they follow with every case? What if you ask them, what if their answer is going to be to a question that's not in any notes? Did you meet with this client of yours alone? Because typically when lawyers do notes, I'm not so sure that the great majority are going to put, I met with the client alone. Okay, now sometimes you do, but it may not be that is the qualifier that you've put in, so you may have to ask that. Maybe the lawyer can say, I have never met with someone I've drafted a will for and had a beneficiary in the room. I don't know if that's true or not, but you don't know. And if they say that is their general practice and they've drafted 100 wills, then maybe a judge is going to believe that. So in looking at a lawyer's file, it's not simply just looking at whether there's notes or reporting letters. Of course, that's the standard that we would all hope to attain. But as the examiner, that doesn't end my questions. Now, with respect to an action, you are going to ask the same questions. Issues of privilege change, where there's solicitor-client privilege to be dealt with in terms of an application and the production of a file and getting the information from the lawyer on examination. And those same types of privilege, if you're being sued by a client, are not there. If the client is going to sue you, you don't need an order for production and a waiver of privilege. One of the first steps then is in determining how you're going to proceed with your examination is what role did the lawyer play? What do you understand about that role? Is this a long-time relationship? Was it a one-off? Is it a complex matter? Is there a lot of emotional, deeply rooted issues within the family itself that are going to come out and have to be dealt with? And sometimes for your own client's purpose, not just for the lawyer you're asking, but how are you going to approach certain things? Obviously, as I've mentioned, and it would be subsumed that you would need to get the lawyer's file. You would want the lawyer's entire file, but be mindful that you're not going to get more than the lawyer's file to the issues that are defined in the pleadings. So if you want more, say for instance, the lawyer was involved in 10 separate transactions or documents for the client, and you ask for all of them. Well, what are the issues in the pleadings? So if it's by way of an application, be mindful that the application itself probably doesn't set out all the issues. You probably have an order giving directions that sets out the issues, and the lawyer who's counsel for the lawyer being questioned is going to try to stick to those issues as firmly as they can and not allow any questions that aren't relevant. So if in thinking of what your examination is going to be like, you need to think about how are we going to set up the issues and how are we going to define them in the order giving directions. Different than in an action, because in the action you set out your factual allegations and then you're going to be governed by those when you do your examination. And so it should be no surprise that if you haven't pled that capacity is an issue in a will challenge, that a lawyer who is representing a lawyer being examined is going to say, what's the relevancy of a question that deals with capacity? Even though people think about capacity naturally, if it's not pled or it's not in an issue, if I was counsel for that lawyer, I would decline and refuse that question. So in terms of how you prepare a witness, I don't think it's any different. But to me, again, it's about understanding the story, okay? And cases are about stories and how the facts fit together to make the story and make it so that if you go down to King and Bay and you ask someone about your case without naming names, do they raise an eyebrow? And if they raise an eyebrow and your client understands that and how the facts fit together, then they're going to be better prepared.
Thanks, Craig. Just one quick question before we wrap up. Noah, what about the role of social media and how that fits into this whole area?
So, as I mentioned, I think a great examination for discovery begins with the affidavit of documents. Ian Hall mentioned earlier on that no one really talks on the phone anymore. And I'm finding more and more that social media is like a treasure trove of evidence that we're using in our files. And when you're doing that reporting letter to the clients in the affidavit of documents, you want to remind them of their obligations that certain social media vehicles include documents that you should be putting in your affidavit of documents. We recently had a dependent support claim, and the individual seeking support had all these amazing pictures on Instagram of these lovely vacations they took and the beautiful cars they were renting. Now, obviously, if you get to trial, you got to think about the Evidence Act and request to admit. But at an early stage, you got to really gather those documents and use those as key evidence. And again, it begins at the get-go when you're doing the report to the client about the type of information and documents you need from them.
Go ahead, Lisa.
I would add on the flip side to that is, as the examining lawyer, there are a lot of open social media profiles. Right. So there are a lot of people that don't have locked Facebook accounts or locked Instagram accounts that are a treasure trove for the examining lawyer to look at as well. So it cuts both ways.
Part of your preparation is the social media. Thank you so much.